Welcome everybody. It's time for Literally with Lolo. That's not really the jingle, but it'll work for now. So come along with me as we step through the 29-page response from the Trump defense team to the Department of Justice regarding Trump's desire to wantonly use actual evidence in his political campaign. So I'm going to bring it up on the screen and we're going to take a look at what they're saying. All right, here we go. So this is the filing on 8/7 on the U.S. versus Donald Trump. Response in opposition to the government's motion for a protective order. Oopsie poopsie. We don't want to, do we? Okay, so blee blah blue allows the court to enter protective orders limiting the use of sensitive discovery materials that present particularized safety or security concerns. But instead of hewing to this narrow framework, the government requests the court restrict all documents produced by the government, regardless of sensitivity, contrary to established law and President Trump's First Amendment rights. To resolve this issue, President Trump respectfully requests the court adopt the attached red line. Yes, we created a red line for you. We're quite cheeky over here in the John Lolo office. Cheeky paralegal. So that narrows the proposed order to shield only genuinely sensitive materials from public view. This more measured approach is consistent with other protective orders entered by this court in cases concerning the events of January 6, 2021, and appropriately balances the government's claimed desire to protect highly sensitive categories of material and expedite the flow of discovery. Motion at 3 with the rights of President Trump and the public to free speech in an open proceeding. Doesn't it sound so just wonderfully open and transparent? Well, let's just see why the president might want to do this. Okay, we're going to go right into the argument. In a trial about First Amendment rights, which of course this is not, but yet we're going to insist that it is because frankly, it's the easiest thing to argue. It's not very complicated, and frankly, that's the way we like it. Not complicated. Okay. Though the government seeks to restrict, oh dear, the First Amendment rights, worse, it does against its administration's primary political opponent, which he did after he understood that there were indictments coming down the pike. So, there we go. Blee blah blue, I don't know, let's see, a red line over the weekend. Oh boy, this is just a bunch of little bullshit right here, just complaining about the homework that they had to do. So that's really ridiculous. Oh Jesus, it really is. Oh my God, it's complaining that they didn't have enough. What the hell is this? Jack Smith delivers statement on August 1st. Gratuitous out-of-court statement to media regarding allegations in this case. Gratuitous is not the word that comes to mind when I think about Jack Smith delivering a statement. I mean, if it were gratuitous, he wouldn't be wearing a shirt. So there's that. Okay, and Schumer Jeffries joint statement on the federal indictment. Well, that's protected speech, darlings. That's kind of speech and debate shit. So, there you go. Glenn, well, and actually it ends up being truthful. I don't know. I'm just going to say, I'm going to call it now. Glenn Kushner, why this Trump indictment? Well, Glenn Kushner just really doesn't like you, Mr. Trump, and so you just have to expect that. Yes. Falsely claiming, well, probably not, based on this case, that he attempted to end our representative. Well, no, actually, that's probably objectively true. So there's that. President Biden is likewise capitalized on the indictment. Look at this. Look at this beautiful ad that he did. Look at this beautiful ad that he did. Actually, thank you. I'm so glad you noticed. Hate me 'cause you ain't me. That's what this little section is subtitled. Hate me 'cause you ain't me. Okay. Well, that's great. That was a nice picture of Joe you have in there. That's fantastic. Okay. And then Twitter. Yeah, blah, blah, blah. Okay. throw at Joe Biden appeared to throw major shade at a thrice indicted Trump with a dark Brandon meme, and Twitter loved it. Hee hee. It's true, we did. We really, really, really did. Well, so the government is requesting the court to assume the role of censor and impose content based regulations on President Trump's political speech that would forbid him, like, listen, people, it would forbid him from publicly discussing or disclosing all non public documents produced by the government, including both purportedly sensitive materials and non sensitive, potentially exculpatory, although we haven't seen them yet. So, how can we possibly know that they're exculpatory? But it's a great word to throw in here because it immediately shifts your mind to exculpatory, right? Yes. This untargeted method offends both the First Amendment and my mother, which requires a compelling government interest and narrow tailoring to justify a prior restraint. Blah, 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 blah. Let me quote this shit. Well, it's actually, interesting that here we're just making the admission that we're going to disclose all non-public documents produced by the government. That's the subtitle of this section is I intend to disclose all non-public documents produced by the government. There you go. And I'm going to make them exculpatory. I'm going to rewire them. I'm going to find Dan Scavino. I'm going to say, Danny, you need to sit down at that computer and open your Photoshop. We've got work to do. So there's that. I predict. With request to speech, the First Amendment has its fullest and most urgent application precisely to the conduct of campaigns for political office, which is really, really interesting because I think there are specific restrictions on free speech when it comes to evidence within an ongoing trial. I don't think that falls under free speech. I could be wrong. I'm not a lawyer, but I think I'm not. So there. Okay. Governor cannot survive a rigorous review. Well, rigorous isn't really a word that comes to mind immediately when we talk about Mr. Trump or any of his legal team. Here, President Trump does not contest the government's claimed interest in restricting some of the documents it must produce, such as those containing Rule 49.1 information and Rule 6 grand jury materials. However, the need to protect that information does not require a blanket gag order over all documents produced by the government. Rather, the court can and should limit its protective order to genuinely sensitive materials, a less restrictive alternative that would satisfy any government interest in confidentiality while preserving the First Amendment rights of President Trump and the public. I mean, we're doing it for them, darlings. Really, come on now. So basically, we're just saying, we can't tell you what we're going to release, but because earlier we said we would release all non-public documents, but then now we're saying maybe we would agree not to do the sensitive ones, but it depends on whose definition of sensitive you're using. I have a feeling maybe that would be the loophole. Now, wouldn't that be funny? Okay. Let's see what else. I might have missed some important point here, but I probably didn't. Okay. The government does not explain why the protocol would be insufficient. Well, they probably do. Nor does this district regularly prevent the disclosure of non-sensitive documents, as the government suggests. Just the opposite. This is a complete and utter misunderstanding. The court recognizes that a protective order should be limited to documents implicating the, quote, safety of witnesses and others, a particular danger of perjury, of witness intimidation, and the protection of information vital to national security. Well, ding, 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 lawyers. I think you just hit on all 3 points of why we want to limit his use of discovery. I mean, really, is it not that obvious? Okay. So, at all times, the burden of showing good cause for blocking the disclosure or use of a document lies squarely on the government. Well, I think they made their case, and I think they're going to do it, probably this Friday. Whether or not you or your buddy can show up, I don't think they care. So see you in court, suckers. Bleep da blue. Here, the government does not explain how the existence of some potentially sensitive materials presents good cause. Blee, blah, blue. Well, it certainly does. The government states only that here, good cause exists because issuance of the government's proposed order would expedite the flow of discovery in this case, give the defendant prompt access to a large portion of the discovery he ultimately will receive, and protect the highly sensitive categories of material described above. Well, no, I think we actually, maybe the order probably had said more, about sensitivity. So there we go. But the government has already identified the documents it believes are sensitive. I mean, really, it sounds to me like that's what it is, meaning that restricting non-designated documents would provide no benefit to the flow of production. Likewise, even if such benefits existed, and they do not, it would justify indefinite closure of non-designated documents. At most, it would only counsel a brief period of closure to allow the government time to make designations. That's right, they would use that time to cheat and make everything sensitive. I know them. I know them. They borrowed my weed whacker and they will never return it. Accordingly, President Trump respectfully requests the court to adopt the proposed red line because really, we know what to do here in the lawyerly offices of John Law, lawyer at large. And highly sensitive, blah, 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 blah. Sensitive, sensitive, sensitive. Other disputed revisions. Oh, it's not just the sensitivity, people. It's not just they're tying our hands to misuse discovery. Despite the extraordinarily limited time President Trump had to prepare this response, we attempted to confer with the government in good faith over the weekend. Oh, God, we're going to devote an entire section to whining. Unfortunately, the government declined a cooperative approach, refusing to provide any real-time feedback. Ultimately, just hours before our deadline, the government notified defense counsel it would propose most of our revisions. Although time limitations prevent us from fully explicating every proposed edit, we address several significant issues below. Once again, we believe it would be beneficial to set a hearing on this matter. Oh, please, please, please. If only they could televise that. I don't know. I know, I understand, but I just want to see them try and argue some of this stuff you don't understand. I think that's what we need in this country. Definition of authorized persons. Authorized. What does authorized really mean? What does persons really mean? The government requests that the court limit disclosure of materials to only certain members of the defense team, defense counsel, which it defines as counsel of record in this matter, and persons employed by defense counsel. This limitation is unreasonable and unworkable and not supported by any legitimate interest. It means we would have to read him every document. Well, actually, we'd have to do that anyway, but that doesn't matter. Defense counsel may choose to bring on, for instance, volunteer attorneys. Oh, who in the hell would work for free? I do not understand how that would, or maybe you would just be using students, or others without paid employment arrangements to assist with the preparation of the case. Oh, so any random Joe will be coming in and able to see all of the documents that we present. And that's really what we need. We want unfettered access, and we want to bring on any schmo that walks in off the street that we can put in front of a set of classified documents. Sounds like a real great idea. What a fucking brain trust you've hired, Mr. Trump. Such a limitation or requirement would unduly burden President Trump and impede the efficient preparation of his defense. Well, I just don't think that's really true. Nor would allowing volunteers access to discovery appreciably increase the risk of improper what? This is the dumbest thing I've ever heard in my life. How do people go to law school and get out? I understand they're doing it to be dumb, but how is this allowed as a waste of taxpayer money? My God. Okay, striking out all that. So this is what they did. The defendant and defense counsel shall not disclose materials or their contents directly or indirectly to any person or entity other than persons employed to assist in the defense, persons who are interviewed as potential witnesses, counsel for potential witnesses, and other persons to whom the court may authorize disclosure, collectively authorized persons. Potential witnesses and their counsel may be shown copies of the materials necessary to prepare the defense, but they may not retain copies without prior permission of the court. So what I just read was what the DoJ had in their order. And you can see all the changes that they're making. These guys are idiots. Definition of sensitive materials and the markings, because we don't really understand them since we'll never get a clearance. The proposed red line adjusts the definition. Oh, interesting. Okay, interesting idea. Adjusting the definition of sensitive materials to exclude certain documents obtained outside the grand jury process. What the hell does that matter? Ay. The government objects to this revision as defining too narrowly the categories of sensitive information. Right. But as explained above, these red lines are consistent with the law and the routine practice of courts in this district, including other January 6th related protective orders. Well, I really don't think the impact of the cases can be compared. So thank you, but no. The government has not and cannot articulate such materials should be protected from disclosure in the same manner as grand jury materials. Well, that's just silly. Moreover, the government declines without comment Trump's reasonable request that it conspicuously mark the documents it designates because he needs a big fucking marking saying, don't share this. So if they could only put cover sheets on everything that say, don't share this in crayon, he might read it and he'd still share it. So, again, what the DoJ wrote: the United States may produce sensitive materials to defense counsel, including the below materials. Materials containing personally identifying information as identified in federal rule, blah, blah, blah. Rule 6 materials, including subpoena returns, witness testimony, and related exhibits. Materials obtained through sealed search warrants. Sealed orders obtained by the government's filter team related to this case. Recordings, transcripts, interview reports, and related exhibits of witness interviews. And yeah, that's it. And materials obtained from other governmental entities. That's what the government wrote. The government will indicate to defense counsel in discovery, correspondence, or otherwise which materials constitute sensitive materials or prior to or concurrent with disclosure. That's it. Yeah, fuck you. You don't get your fucking hand. We're not holding your dick while you pee. That's what the DOJ is saying. The government appears likely to designate a large portion of the material it produces as sensitive. That's right. President Trump reserves the right to object to those designations. It doesn't fucking matter. If beggars were choosers, no, wait. If beggars were horses, no, if wishes were horses, beggars would ride. I never get that right. Despite this, the government seeks to obstruct Trump's defense by requiring him to seal every single time he wishes to cite sensitive designated material, whether in response to a motion during a hearing or at trial or on Truth Social. That part is missing. So then, President Trump proposed a more streamlined approach, wherein designated documents could be filed under seal without leave, subject to a party's motion to unseal. Proposed red line. The parties may include designated sensitive materials in any public filing. Blah, 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 blah. Well, I don't even know what that means. Well, they just didn't put the right writing in there. Okay, anyway, we're going on. Similarly, he proposed clear procedures for handling designated documents at hearings. Oh, really? He did? I don't think so. Without leave, if all court designated parties may. Oh, yeah, no, that's all bullshit. The proposals would ensure designated documents remain closed from public view as both proposed protective orders contemplate, while minimizing the administrative burden imposed on Trump and the court. Yet the government rejected the edits out of hand. Why? They do not say. But what explanation could the government have? Initial sensitivity designations are its decision under both the proposed order and the proposed red line, and are supposed to reflect the government's view that the public disclosure of mock documents would be harmful. Thus, the government could not reasonably object to sealing such documents. In conclusion, Trump respectfully requests the court adopt the proposed red line. Todd Blanche, I don't really have a license. And John, I said what I said, Lolo. Lolo and Singer. Singer, who's currently looking for an exit strategy. So this is all, let's see what all of these little silly eggs. Oh, so this is the actual red line. Well, fuck them and the can of horses they wrote in on. Let's see if there's anything else that's kind of interesting. Oh, probably not. Oh dear. Well, oh, Judge Chutkin, please be safe. Oh, here we go. Here's some fun little tea. Well, here, Monday. Well, okay. So Monday at 11 a.m. at noon, basically, you sent an email and you think that's all weekend? Thanks for the red line. We've had a chance to review it, and we don't believe we'll be able to come to an agreement on most issues, as discussed yesterday. Among other things, we're concerned that your proposed protective order defines too broadly the legal team that could access the discovery material and defines too narrowly the categories of sensitive information. That said, we have no substantive objection to the proposed edits below. Well, look at that. The government gave them some concessions. We're on Sunday. Okay. Hi, Thomas. Okay. So this is Sunday. Okay. Hi, Thomas. Thanks for the input. I don't know who Greg is. Molly Gaston. Well, she's a really wonderful person from the DOJ. Here we go. To Greg. Thanks for sending this. We have a few questions to make sure we understand the red line. Happy to jump on a call. Well, this seems very congenial. What is the outer limit of the proposed definition of persons assisting in the defense? The wording you propose could be read as almost boundless. It's true. It's so accurate. Should the edit say not reflecting, consistent with the proposed red line in paragraph 4, instead of reflecting? Did you basically get the entire point wrong, Joe, in paragraph 6? Paragraph 8. Discovery will include transcripts and recordings of witness interviews conducted outside of the grand jury context. Our position is that those materials are sensitive. Your proposed edit removes those materials from the sensitive designation. We wanted to confirm what your position is on those materials. So what's it going to be? Gregory Singer. Oh, Greg. Oh, so Greg's in. Balls deep. He's balls deep. Okay. Understood. All right. Let's see what else we've got here. Okay. So this is Saturday at 6 in the evening. Oh, so Saturday at 6 in the evening, would the government team be available to meet and confer 1 to 2 p.m. tomorrow to discuss competing orders? Okay, so let's be real clear. Judge Chutkin issued her order on Friday night. Saturday night, not Saturday morning, not Friday night, not midnight. Saturday night, they asked for a meeting for Sunday afternoon. They didn't use any of their time to work it out with the Department of Justice. So, fuck you, Mr. Thrice indicted and soon to be a fourth, going to prison for the rest of your miserable life. Yeah, you are. Yeah, you are. You're freaking going to prison. Yeah. Oh my goodness. What an adventure. What an adventure. Thank you for stopping in with Literally with Lolo. And have the most amazing Monday, right? No, Tuesday. Oh, geez. Sorry. I blame the Maui Wowie. So, but go in peace and let's hope for a more perfect union. Let's work towards media literacy. Voting rights first. Trans lives matter. Black lives matter. We have to stand up for each other. And I am saying that to myself as much as any of who might be listening. So just know I'm sending out hope that we all find a way to love each other more and restrict each other less. So, thanks, and here's to justice. Woo! Have a wonderful week. I'll see you at the lounge. Bye.